The third point that I wanted to make has to do with oral argument. And that is, you're going to face a panel that has spent a lot of time with the written argument, and because you're thinking about it in terms of the decision that has to be made, although you haven't decided the case, you've certainly developed some views. There's no question about that. Now, when you're getting ready to argue the case, you have to take that into account. You have to take into account where will the court have been moved by reading the written material, and you have to be as objective as you can about what's the court going to come in concerned about. Now, my best advice for you is you have to picture the back and forth that in fact goes on, which is there's a judgment coherent within itself. Then there's an appellant's factum, and when we read that, you say, well, maybe there is a problem with the judgment. Then there's a respondent's factum that's going to move the match in the other direction. Say, well, there's nothing wrong with the judgment because of what the judgment says, or maybe some things that the judgment doesn't say. Now, if you're the appellant, that's the state of play, because you don't get a written reply. But you have to take that into account when you're walking into court. And that's why, for me, it's much more helpful if you come in and you say, instead of, my factum makes 6 points and then repeat them, if you present your argument in a way that recognizes what the respondent's answer is. So instead of saying, my first ground of appeal is the judge erred in letting the other side's expert testify to matters that weren't in his report, you might say, there's that error, and right up front say, and the respondent's answer that the judge gave me overnight to prepare my cross-examination is no answer, and I'll tell you why. So let us know that you're engaging with the issues, because it's all about decision points. I have to say that the most frequent question I've asked since I've been appointed has been, the appellant says or the respondent says X. What do you say about that?